Judgment in the appeal, FirstGroup Plc and Paulley.
Mr. Paulley is a wheelchair user. On the morning of 24th February 2012, he was hoping to catch the 9:40 bus from Wetherby to take him to Leeds, where he was going to catch a train to meet his parents for lunch at Stalybridge. The bus had a space marked with a wheelchair sign and a notice saying, "Please give up this space for a wheelchair user." When Mr. Paulley tried to get on the bus, a woman with a sleeping child in a pushchair was occupying this space. The driver asked her to move, but she refused, stating that her pushchair did not fold down. Mr. Paulley had to wait for the next bus and missed his train as a result. He issued proceedings against the bus operators, FirstGroup. He claimed damages because, he said, they had failed to make reasonable adjustments to their policies to accommodate persons with disabilities as required by the Equality Act 2010. At trial, Recorder Isaacs said that FirstGroup operated a policy whereby a non-wheelchair user occupying the space on the bus would be requested to move, but if the request was refused, nothing more would be done. He held that FirstGroup could have made reasonable adjustments to eliminate the disadvantage. First, by altering the notice positively to require non-disabled passengers occupying a space to move if a wheelchair user needed it. Secondly, by positively requiring non-disabled passengers to vacate the space, if necessary, by having them leave the bus. The Recorder awarded Mr. Paulley £5,500 damages. FirstGroup appealed, and the Court of Appeal allowed their appeal. The Court of Appeal considered that it was not reasonable to expect FirstGroup to alter their notices or adjust their policy in the way that the Recorder decided. Today, the Supreme Court unanimously allows Mr. Paulley's appeal, albeit only to a limited extent, for reasons in a judgment given by me, supplemented by a judgment of Lord Toulson. Lord Reid, and with express reservations Lord Sumption, agree. Our reasons in summary are as follows. The Court of Appeal was right to disagree with the Recorder's conclusion that FirstGroup should have a policy that could lead to a non-wheelchair user being ordered off the bus. A rule that any non-wheelchair user must vacate the space would be inappropriate. There are many circumstances in which a non-wheelchair user might reasonably refuse to vacate a space, and even more, to get off the bus. Even a rule that any non-wheelchair user must vacate only where it is reasonable would not be acceptable if implemented through mandatory enforcement. It would be likely to lead to unacceptable delays for, and sometimes confrontation with, other passengers, particularly in the case of a full bus. Passengers are at least arguably not subject to a statutory obligation to comply with a policy relating to the use of the space, and they would not appear to be under an obligation to get off the bus if they fail to do so. Further, FirstGroup cannot be criticised for not expressing the notice in more forceful terms. It did require non-wheelchair users to vacate the space, albeit politely, and there was evidence that polite notices were more effective. The suggestion that the notice should state that priority of wheelchair users, quote, would be enforced, unquote, would be false. Nonetheless, although it was not an argument pursued in the Court of Appeal, we accept Mr. Paulley's case that FirstGroup's policy should have gone further than it did, although not as far as the Recorder concluded. It was not enough for FirstGroup to instruct its drivers simply to request non-wheelchair users to vacate the space and to do nothing further if the request was refused. The approach of the driver must depend upon the circumstances, but where the refusal to move is unreasonable, some further step to pressurize the non-wheelchair user to move should be considered. The request should be rephrased as a requirement, particularly where the non-wheelchair user could move elsewhere in the bus, and a refusal to drive on should be considered in appropriate cases. So far as damages are concerned, as the Recorder did not consider whether, if FirstGroup had simply required their drivers to be more forceful, it could have made a difference in this case. It is therefore not possible for this court to conclude that there would have been a real prospect that such an adjustment would have resulted in Mr. Paulley being able to board the 9:40 bus to Leeds. Lady Hale, Lord Kerr and Lord Clark, the other three members of the court, dissent in part. They would have restored the recorder's judgment and they would have also awarded Mr. Paulley damages. The court is now adjourned.